My name's Lewis O'Brien. Over the past 25 years, I've helped clients, friends, and family buy and sell thousands of homes. In these 5-minute guides, I'm going to cover a series of topics that I think all home buyers should be aware of. However, unfortunately, too many home buyers don't know that they need to know these things or don't know who to ask. To make sure that you don't miss out on future videos, please tick the red subscribe box in the bottom right-hand corner of your screen. Okay then, let's get on with it. In this segment, we're going to talk about building and pest inspection conditions, what they look like, when to use them, and how to make them work for you. Unfortunately, I've had the experience of clients who haven't understood the limitations of these clauses, ended up with building repair costs that they hadn't budgeted for and rather spoiled their purchase experience. I'm putting up on the screen a relatively common building inspection condition, and I'll give you a couple of minutes to just read through the words of it. The first thing you need to know about this special condition is that you need to tick the box in the particulars of sale to actually activate the condition. Now, this assumes that you're using the most recent version of the Law Institute Real Estate Institute real estate contract. In the case of other earlier versions of the standard form contract, you may actually need to insert your own special condition. But either way, the first point is that you need to make sure that the condition is both present and activated before it'll work for you. The next key point is that this condition will only allow a purchaser to terminate if their registered builder identifies in their report a material structural defect. Now, the meaning of material structural defect is probably clear enough when you think about it. However, I've certainly had cases where, for example, there was a leak behind a shower which had caused some rotting and would require a $10,000 or $15,000 repair and replacement exercise, but it didn't count as a structural defect, and therefore the client, notwithstanding they had a huge expense they weren't budgeting for, was not able to terminate the contract. Another example of something that's not a material structural defect is works that are unauthorized. So, for example, the requisite permits are not in place or builder's warranty insurance. However, in some cases, unauthorized works that are not fully disclosed may allow you to terminate the contract under your statutory rights under the sale of land. If you find yourself in a position where you want to terminate the contract using the building condition, there are a few things to be aware of. Firstly, like the finance condition, if you do nothing, the contract will become unconditional. So if you want to terminate, you actually need to send a notice to the vendor. Time isn't usually an issue, but I guess it's technically possible to request an extension, maybe in circumstances where you're looking to renegotiate the transaction as an alternative to terminating the deal. If you are terminating the contract, you need to provide written notice to the vendor or the vendor's solicitor and include a copy of the building inspection report that confirms the major structural defect. The other condition to be aware of is that you're not entitled to terminate the contract if you're in default. The most obvious default, of course, is failure to pay the deposit. So you may find yourself in a situation where you are paying the deposit to make sure you're not in default so you can terminate the contract. I've set out on the screen below a better format of the special condition. And when I say better, I mean more in favour of the purchaser. There's a couple of key points to note. The first is that the building inspection is to be reasonably acceptable to the purchaser. That is, we don't need a material structural defect. We don't need any particular criteria. It's just basically if you as purchaser don't like the results of the inspection, then you're entitled to terminate the contract. The second major difference is this clause makes it clear that if the building inspection report's not acceptable, then the deposit is to be refunded without delay. A couple of other things you'll notice: there's no need for the person doing the inspection report to be licensed, and it doesn't contain that condition that you can only terminate if you're not in default. From a purchaser's perspective, I think this is a better format. To round out this guide, I just want to touch quickly on the pest inspection condition. The standard condition is generally drafted in a similar fashion to the building inspection condition and suffers from the same sort of restrictions and conditions. Specifically, the standard Law Institute version requires that you have an active termite infestation. That may not cover all of the issues you're worried about, because there are certainly borers and other sorts of insects that can cause damage. A condition similar in terms to the building inspection condition on the previous slides is certainly going to be more favourable to a purchaser. By being aware of the limitations and conditions of building and pest inspections, hopefully you can use these conditions to ensure that you don't end up buying a lemon with an expensive repair bill, and that you do indeed have the positive, celebratory experience that buying a home should be. As always, this 5-minute guide is intended to identify key issues and errors that clients make, and is not intended to be a substitute for specific legal advice. I hope you've enjoyed this video and got some value from it. If you have, then I'd encourage you to share it with a friend, like the video and subscribe to the YouTube channel, or subscribe to our newsletter at lewisobrien.com.au. We do intend to create a series of videos, but your feedback and suggestions will be invaluable.